work session on AMC 3.70 for today. We'll begin by going around and doing our introductions, and if we can, Mr. Birch, we'll start with you and we'll finish up with Ron.
Chris Birch, Anchorage Assembly.
Dick Green, Anchorage Assembly.
Elby Bridget.
Cheryl Frasca, Anchorage Assembly.
Debbie Osiander.
Adam Trombley, Assembly.
Jennifer Johnson, Assembly.
Ernie Hall, Assembly.
Dan Sullivan, Mayor.
Mike Tedesco.
Justin Roberts with IBAW.
Chuck Donegan with a number of municipal unions.
And Rod Harrison, firefighters.
Mr. Starr is excused for today. He's tied up, but I expect to see Mr. Honeman and Mr. Flynn joining us hopefully very shortly.
Mr. Hall, could we know who Mr. Tedesco is representing?
Oh, I'm sorry. I'm a professor from the University of Oregon, as well as someone who represents the APDEA.
Thank you.
And let the record show that Mr. Honeman has joined us.
Had to stop on disabled vehicles.
And with that, I will hand this over to Mr. Harris.
All right. Thanks, Chairman Hall and members of the Assembly for this opportunity to address you today on the ordinance. The municipality has a good history of collective bargaining, and to our understanding, no contract negotiations since 1990 have resulted in arbitration. And along with that, there have been no strikes. So it's difficult to understand how this legislation is going to benefit Anchorage and why such a substantial change is even needed. And leaves us asking, what is the true intent of this legislation? The goal of any legislation is to provide a clear and concise process that allows the government entity to operate efficiently and protects them from challenges of litigation. This legislation does not appear to provide none of that. We have had this legislation now before us for 2 weeks, yet there are still more questions than answers in the mayor's proposal. Nearly every proposed change in this ordinance brings up a whole new set of issues. This is a radical revision of the municipal labor ordinance. There are dozens of legal issues that arise from undefined terms and subjective standards that even the mayor's administration cannot provide complete answers for when they presented the ordinance to all of you last week. Because of the ambiguity and lack of clarity with this proposal, it is impossible to address all of the problems with the Assembly Ordinance 2013-37 today. But we have 3 professionals, attorneys that are experienced in labor law, who will represent some of the many problems that we have already become aware of with this proposal. As you just heard, Mike Tedesco is a labor attorney since 1978 with the Tedesco Law Group, and is also a professor of law at the University of Oregon's Law School in labor law and arbitration law. Mr. Tedesco represents APDEA and is a graduate of William & Mary and Southwestern University School of Law. Our second presenter is Chuck Donegan, co-founded the law firm of Germain & Donegan in 1976. He's been, for the last 37 years, representing public sector and private sector unions, and including their pension and health care plans. Mr. Donegan currently represents the AMEA, my organization, and the Plumbers Local 367, and as well works regularly with the Coalition of Municipal Unions. And then finally, Justin Roberts, who's practiced law up here for about 12 years and represents the IBEW in Alaska. Mr. Roberts has also been an advocate in numerous arbitration hearings and National Labor Relations Board proceedings. Everyone has a copy of the PowerPoint being presented today, which will take us about an hour to get through the presentation, and then at the end we'll turn it back over to Mr. Hall for questions.
And if I may, Mr. Harris, just before you start, I want to have basically the same procedures that we used at the last meeting. We want to show the courtesy of you going through your presentation without any interruption, and then I will do the same thing in regards to my fellow assembly members asking questions. Each one of them will have the opportunity to ask their questions without interruption. So with that, please continue.
Thank you. Chairman Hall, is it all right if I stand up, please?
Yes, sir.
Thank you. We want to give you a brief overview of our concerns regarding the proposed ordinance. We think it does, in fact, create a radical revision of the municipality's labor ordinance, and it abandons 44 years of experience with this ordinance. Importantly, it also abandons the process established by the National Labor Relations Act and the laws that have been defined by the federal courts and the U.S. Supreme Court since the 1930s. It uses many undefined terms, and frankly, some of the terms are confusing and contradictory. Already, as I understand it, for last Friday, the Assembly has heard members of the administration's team disagree on basic definitions and meanings of these terms. We also would like to point out that this presents a significant shift of power away from the Assembly and toward the executive, and that we are abandoning such principles that are fundamental, such as seniority for vacation selection. When you abandon those principles, what's there to replace it? How's a manager supposed to manage? It replaces overtime rules with a strict adherence to the Federal Fair Labor Standards Act, the country's minimum wage law. That, in and of itself, will cause the municipality to spend considerably more money on overtime, because now there are negotiated agreements with the labor organizations that modify the ill effects of the Federal Fair Labor Standards Act. And we point out that this proposal was not developed collaboratively. Insofar as we know, department heads, managers, unions, and the Assembly were not sought, much less considered, in the changes we're about to see. Let's start with a starting point. Under the proposal, you as the Assembly will be restricted in terms of evaluating labor contracts to making sure that a concept called direct labor costs will be within some consumer price index. Now here's the problem. The term direct labor cost is not a commonly used term in labor relations. It doesn't exist. And by the terms of this proposal, you'll have to define it. And you'll have to define it in the context of the words that it's used. You will be restricted, the Assembly will be restricted, from looking at such things as market considerations, which is the primary motivator in a labor agreement. You won't be able to deal with issues respecting changes in jobs that are necessitated by changes in technology and changes in growth and changes in your ability to be responsive to the needs of the citizenry. The term direct labor costs also involves a word, benefits. Now, most of us can think of a common definition of what benefits is. The problem is the proposal really doesn't define what benefits it's talking about. For example, health insurance, we would commonly think of as a benefit. What portion of health insurance, however, are we talking about here when we're going to add up to direct labor costs? Are we talking about premiums? Are we talking about the actual content of the benefits themselves? There's a whole host of other things that we've listed here. Let me just point out a couple. Family Medical Leave Act is a benefit. How do you quantify that? How does a municipality going to quantify that? And why is that important? Because you as the Assembly are going to have to deal with that issue when it comes to approving the ratification of an agreement. And you're going to be restricted in doing that to these direct labor costs. Direct labor costs, according to the agreement, according to the proposal, has to include taxes. What taxes are we talking about? Here's just a few. Payroll taxes, workers' comp, unemployment insurance. Some of these were employer-only paid taxes. Are we going to use those employer-only paid taxes? And are we going to cost that against a future increase under the Consumer Price Index? And does that raise legal questions about whether the municipality legally can pass on that cost to the employees? An interesting part of this also is the reference to the CPI. Let's take a look at that. The proposal states that you're limited to the direct labor costs to the Consumer Price Index as CPI-U. And it says the CPI-U is the year-end index provided by the State of Alaska Department of Labor. There's many problems in that sentence, some of which you're not going to be able to deal with. For example, the State of Alaska does not release the CPI. That's a function of the federal government and the United States Department of Labor. more than that, there is no such thing as a year-end CPI. No such thing. There's monthly indexes, there's annual indexes, there's a first half index and a second half index. There's a CPIW, there's a CPIU. There's CPIs with certain things in the marketplace basket excluded. There's local CPIs, there's national CPIs. There's no adequate definition because the definition refers to a CPI that simply doesn't exist. The restriction that you will have as a result of the passage of this is interesting, because there was apparently some discussion on this on Friday as to whether the Assembly would be restricted to a hard cap of that CPIU, or whether that would only be a goal to reach. I read it as a hard cap, clearly from the language that you see here that's in the proposal. The language is a clear effort to tie the hands of the Assembly in making future determinations as to what an appropriate wage increase would be. I can't think of another place that has such a restriction anywhere. We think there's a need for flexibility in terms of your deliberations when you assess the appropriateness of a labor contract. You should be able to look at the market. To do the right thing by the citizens, you need to be able to assess the labor market. You need to be able to assess recruitment and retention rates. You should be able to assess the changing nature of employment in the city, particularly as technology grows and as new business comes in. You should be able to look at more cost of living, well, certainly an appropriate cost of living standard. You should be able to determine the employer's ability to pay. You're not given those responsibilities under this proposal. For example, the Affordable Care Act is going to very soon likely change the way health insurance exists and what it's going to cost. How will you as an assembly be able to respond to that given this proposal in the future? The answer is you get an up or down vote and that's it. Your hands are tied. You can't discuss it. You can't consider it. So there's some core definitional problems here. And beyond that, there's a the comment that was made by Rod is exactly right. Every time you look at a definition here and you peel it away, you see other problems. So for example, when you think about direct labor costs, how are you going to handle a situation where there's an expansion of an employee work group for some reason? Will that labor cost, that additional labor cost, be held against the existing employees? And will that labor cost be used to actually reduce the pay of existing employees? What if you're in a circumstance at that point where, because of labor market forces, you're not able to attract people with the skills and abilities that you need? You as an assembly will have your hands tied. You will not be able to deal with that issue. So there are core definitional problems. Beyond benefits and taxes, which we've talked about, there's this concept of pay enhancement, and my colleague Chuck is going to talk about that a little further. We don't know what that term means. That's not a labor relations term. Special pay, allowances, pay steps. Is that a pay enhancement? Is that a longevity step? Is it even okay to have a contract from this point on where pay steps will be allowed? What do you do with the people who are on the pay steps? What do you do with the person who's in the last year right before he hits the top step and now you're saying, well, you can't have it anymore? Because I read this to say you can't have pay steps. Now, if all that wasn't enough, you got a couple of other large problems. One is overtime. The Federal Fair Labor Standards Act is the minimum wage law of this country, and it sets the basis for what pay can be. Sometimes, however, it's important for a municipality to work with the unions and to make adjustments in the way the FLSA operates, and you do that on a routine basis. Unfortunately, the way this proposal is worded, you will not be able to do that in the future. You will be stuck with what the FLSA prescribes, with no exceptions. So, that's a different approach than is taken in every other major West Coast city, county, and state. This would be a first. FLSA rules are complicated. I can give you one quick example. A police officer is able to work before they hit the overtime limit 171 hours in a 28-day period. Well, they work generally 40-hour weeks. So let's say one of those police officers has a serious illness, is off a couple of days. Under the Fair Labor Standards Act, that time off does not count toward the computation of overtime. And absent a labor agreement that modifies the provision of the FLSA, that police officer who missed those 2 days of work would be able to work an additional 27 hours within the work cycle